morning, Mr. Gordon.
Good morning, Your Ladyship, and may it please this court. Now, as the court will immediately see, I'm standing in the wrong place, and I just beg the court's indulgence.
You have it.
I'm very grateful. I'm assisted by Miss Duncan, and Miss Chowdhury KC is representing the respondents. Can I just check that the court has, in various forms, the relevant paperwork? There should be a core bundle of 185 pages, a supplementary bundle of 184, and an authorities bundle of 344.
I think that's right, thank you.
And what I propose to do is just to spend a minute or two just reminding the court of the background to this appeal, and then explain the order in which the parties propose, subject to the court's views, to make their submissions. So the background is that the case concerns penalties issued for the late submission of the appellant's 2012-2013 tax return. And as is common ground, the obligation to submit a tax return, and therefore what might trigger the potential liability for a penalty, arises only if a valid notice has been given requiring the submission of that return. We in this court are appealing against the Upper Tribunal on two questions. The first, whether a valid notice requiring the submission of the 2012-2000 return had in fact been issued. And secondly, the validity of the penalty assessment process undertaken for the late submission of that return. The background to that is that the first tier had concluded there was sufficient evidence before it to decide those two questions in favour of HMRC. The Upper Tribunal decided the first tier was wrong about the adequacy of the evidence, but then the Upper Tribunal proceeded to consider the effect of what was then the newly enacted Section 103 of Finance Act 2020. And that was
said that the effect that it found permeated not only in relation to the notice to file a tax return, but also had similar effect in relation to Schedule 55. Is that right?
I submit that it's not entirely clear quite how it reached that conclusion, and I will address it, but I don't think it's going to take this court an awfully long time to work out how it's going to decide the case, irrespective of how the Upper Tribunal did or didn't express itself.
Because actually the Schedule 55 issue is contingent on there having been a notice to file in the first place, so indeed, one falls with the other anyway. If
there is no Section 8 notice, Schedule 55 is irrelevant.
Yes.
If there was a valid Section 8 notice, then there is technically a second question as to whether Schedule 55 has been complied with.
Yes.
That in itself might turn on the same answer as to whether Section 8 has been complied with, or it might turn on its own. And I propose to deal with that very briefly at the end of my submission.
Okay. Thank you, Mr. Gordon.
But the important thing about Section 103 is that it had retroactive effect.
Yes.
Now,
as if it had always been enforced.
Indeed. And we don't fall in any of the transitional rules.
No.
So the Upper Tribunal decided that Section 103 overcame the shortcoming of HMRC's evidence. And that is the question that is the focus of our appeal. We say Section 103 doesn't go so far. HMRC, however, are arguing that the first tier's decision on the Section 8 notice and the evidence was wrong. So they've got the respondent's notice in relation to the Section 8 notice. So we effectively have two issues, our appeal and the respondent's notice. And therefore I propose, and my learned friend has agreed with this proposed way forward, is that I deal with the appellant's appeal. Ms. Chowdhury then responds to the appeal and then makes her arguments in respect of the respondent's notice. I then reply as necessary in relation to the appeal and then give a response to the respondent's notice. And then Ms. Chowdhury concludes as necessary with a reply in relation to the respondent's notice. But obviously that is subject to the court's preference.
That's fine.
Grateful. So moving on to the appeal, I propose to set out my submissions in 9 stages. Some will be dealt with very briefly, I hasten to add. So first, I will explain the appellant's case on the appeal in a nutshell. Secondly, I'll take you to the statutory provision creating the obligation, the Section 8. Thirdly, remind this court of the facts that were established below Fourthly, consider the history which led to the enactment of Section 103. Fifthly, look, as the Upper Tribunal did, at the announcements that heralded Section 103. So there was the pre-legislative material. Sixthly, I will take the court to Section 103 itself. I will then take the court to the Upper Tribunal's discussion on Section 103. And eighthly, we'll show you why the Upper Tribunal's decision was wrong. And the ninth stage is just to address briefly the provisions in the Finance Act 2009. So, subject to that, our case in a nutshell is that the Upper Tribunal wrongly identified the purpose behind Section 103. That led it to misconstrue the section. Most importantly, Section 103 is not a provision seeking or achieving to dispense with the need to evidence officer involvement in a statutory process. And finally, on the basis of HMRC's correct concessions below, even under Section 103, there remains the need for Section 8 notices to be issued under the authorisation of an HMRC officer, and HMRC failed to prove that before the first tier. So, having addressed the nutshell, I would like now to take you to the statutory provision creating the obligation. It's in the authorities bundle found at page 4. This is Section 8 of the Taxes Management Act of 1970, as amended. And we need look only at the first subsection. And indeed, the key words are at the end of the first section of that subsection. He may be required, so that's the taxpayer in non-gender-free drafting, may be required by a notice given to him by an officer of the board, and continues into A, to make and deliver to the officer. So there is the obligation to make and deliver to the officer, an obligation which is triggered by a notice given by an officer. And it's that involvement to the officer that is key to this case. And what I wish to do is just to highlight, because I make reference to it in due course, those words in paragraph A. It's not simply to make and deliver a return, but it's to make and deliver to the officer. So strictly speaking, to comply with the notice, you actually have to make the return to the officer who gave the notice. Moving on to the third stage of my submissions, the facts that were established below. In the first tier, HMRC were put to strict proof to show sufficient involvement of an officer, both in the Section 8 process and as necessary in the Schedule 55 process. I don't propose at this stage to trespass on the subject matter of the respondent's notice, but just flag up for the court's reference the Upper Tribunal's decision, paragraph 22, page 73 of the core bundle, where the Upper Tribunal overturned the first tier's decision in relation to the Section 8 notice, and the equivalent paragraph number 29, page 75, where the Upper Tribunal overturned the first tier's decision in relation to the penalty assessment process. I'd like to pick up the story with what the Upper Tribunal then said at paragraphs 30 and 31. It's page 76 of the core bundle.
Sorry, just tell me again, core bundle at...
76.
Thank you.
My lady. Page 30 and 31. Sorry, paragraphs 30 and 31.
Yes.
And then what the Upper Tribunal says is, had the applicable law stayed the same, we would have allowed the appeal. However, in paragraph 31, the Finance Act 2020 became law. The battleground then sets out what Section 103 says. I don't need to take the court to that at the moment. But then at paragraph 32, we have the battleground. I'll just ask the court to remind itself of.
Yes.
So that's essentially the focus of today's hearing. I now move on to the fourth stage of my submissions, looking at the earlier case law. Now, this is very much background and is not going to be necessarily at the forefront of this court's reasoning, but it's probably useful background because the Upper Tribunal requested a joint note by the parties after the hearing, outlining the history of procedural challenges to departures from the strict wording of the TMA. So that's the first document found in the supplementary bundle. And so there is a history of challenges that had been made. And the first issue there, if I could ask you to look at paragraphs 1, 2, 3, and 4, they talk about the concept of a voluntary tax return. As I said, this is of historical relevance, so I don't want to spend too long on it. But a voluntary tax return was a return submitted by a taxpayer without having been in receipt of a Section 8 notice. What would happen typically is someone who's got a record, a self-assessment record with HMRC, might not have been within the SA system for a particular year, but knew that he or she had to make a tax return, so they just sent it in. Strictly speaking, it wasn't a return under Section 8 because it wasn't in response to a notice. But the revenue would traditionally accept it. What the case law then determined is that that caused problems to HMRC because they couldn't inquire into a voluntary return because their powers of inquiry were only into returns made under Section 8. And if it wasn't a return under Section 8, they couldn't inquire. So Parliament intervened in 2019, introducing Section 12D of the Tax Management Act, which effectively treated any return that was voluntary, but was nevertheless had been accepted by HMRC, was then treated as if it was in response to a Section 8 notice. So it then became involuntary. And the case law then evolved. We have an Upper Tribunal case called Alum, which I think we'll be looking at shortly. Whether or not the retroaction of 12D extended to the inquiry process. It was perfectly clear that a return enacted, sent in pre-2019 was retrospectively validated. But there was a question as to whether or not an inquiry which had been commenced pre-2019 was also valid. The Upper Tribunal has said it was, and I'm not going to challenge that any further.
That's Alum, is it?
That's Alum. Alum also actually dealt with it first, looked at Section 103 as a reasoning, and I submit that Alum was wrongly decided on Section 103. But it doesn't change the ultimate result, because if Section 12D has the effect that the Upper Tribunal said it had in the alternative, then that means the Alum challenge couldn't pursue anyway. So what you decide today will not affect the late Dr. Alum. So far as the present case is concerned, the history is then picked up in paragraph 9 of the joint note on page 6. And that then makes reference to the joint cases of Rogers and Shaw. Now, the case of Rogers and Shaw, they both started as fairly typical £100 penalties for late tax returns. And they were dealt with by the First Tier Tribunal on paper, as most £100 appeals are. Now, the First Tier approach in Rogers and Shaw, the case then went up to the Upper Tribunal. And if I could take this court to the Upper Tribunal's decision, it starts on the authorities bundle at page 167. I'm going to be looking at paragraph 9, which starts on 169. Because the Upper Tribunal sets out what the First Tier did in those two cases. The two cases came together on that appeal. 169, paragraph 9. That's going to take you to 3 paragraphs of the Upper Tribunal, of the authorities bundle.
Be in the wrong place. Hang on.
Authorities bundle.
Yep, sorry, I have got myself in the wrong one. Yes, I'm so sorry to have kept you.
That's no problem.
Paragraph 9.
Paragraph 9. So, Upper Tribunal's reporting what had happened in the First Tier. The First Tier started by considering the applicable law. At paragraph 8.1, it directed itself that the burden of establishing that the appellant is prima facie liable to penalties, which must be assessed and notified in accordance with the law, lies with HMRC. It is for them to prove each and every factual matter said to justify the imposition of the penalties on this particular taxpayer. I can then also look at paragraph 11 further down that page. The First Tier directed itself as what is meant by a notice to be given by an officer of the board. The phrase given to him by an officer of the board means what it says. I would expect any such notice to be signed by a named officer and evidence provided which shows that to be the case. The officer giving the notice needs to be identified in the notice because the return must be made and delivered to that officer. In other words, there must be evidence that the named officer has signed the notice, or it must otherwise be made clear that he is giving it. And finally, at paragraph 14, over on the next page, the First Tier observed that HMRC had not even asserted in their statement of case that a notice under section 8.1a had been given by an officer, and still less did the statement of case identify a specific officer who was said to have given the notice. It noted the generic copy, etc., and then started saying, well, the correspondence talks about we rather than I. I'll just let the court read that quickly rather than hear my voice.
Mm-hmm.
Now, there was nothing wrong with the First Tier's logic about the need for officer involvement in the Section 8 process. The Upper Tribunal disagreed with it needing to be a named officer who was identifiable. That's not relevant for today's hearing. But the underlying requirement for an officer to kickstart the process was uncontroversial. What had gone wrong procedurally in the First Tier Tribunal is that the question about the validity of the Section 8 notice, or the Section 8 process, had not been raised as a challenge by the taxpayer, unlike the present case, I hasten to add, but was identified by the First Tier off its own bat. But the First Tier failed to give HMRC the opportunity to address the point. And what the Upper Tribunal held was there was a procedural unfairness which needed to be rectified. So the appeal was allowed. The Upper Tribunal then actually said, rather than remit, we will take the evidence of officer involvement. They heard the evidence, it was unchallenged evidence, and said, as we'll see in due course, it satisfies the requirement for Section 8.
Mm-hmm.
As to what Section 8 actually requires, evidence-wise, is a matter we will be addressing in relation to the respondent's notice. So I don't need to deal with that now. But I would ask the court to turn to paragraph 32 on page 173, because the Upper Tribunal then gave guidance as to what Section 8 does and what it doesn't require. So in our judgment, properly construed, Section 8 does not impose a requirement that an officer of the board is identified in the notice as the giver of the notice. Rather imposes a substantive requirement that the giving of a notice must have been under the authority of an officer. Therefore, if a police constable, for example, purported to require a taxpayer to submit a tax return, that would not be a lawful request under Section 8, unless the police constable happened to be an officer of HMRC. Instead, the requirement is that whoever requires a notice to be given, whether identified or not, has the status of an HMRC officer. So that is the test that or the definition that was set out by Rogers and Shaw in relation to the question as to what is necessary to satisfy Section 8. And the last point I want to make on Rogers and Shaw is merely for the sense of chronology, is that the case was heard in November 2019, and the decision was published just before the end of the year. And that can be seen on the front page 167 if the court wishes to look there. So that's part of the background. What I'd like now to do is to take the court to my fifth stage and the announcements that preceded the enactment of Section 103. And there was a series of announcements made at the end of October, so just a few weeks before Rogers and Shaw. And if I could ask you to turn to the supplementary bundle, page 22. So this was a written answer in Parliament, and I am conscious that I am now relying on parliamentary material for this. But what happened was there was a parliamentary statement and then a fuller statement by HMRC. If the court doesn't mind, I'll take you to what was said in Parliament, just because it sets out some of the background, but I'll also take you to the non-parliamentary material. So the parliamentary statement is simply what we see on page 22. An announcement by the then FST on the 31st of October about new legislation. And we can see various references to HMRC's use of large-scale, quote, automated processes, a desire to give certain statutory notices and to carry out certain functions. And then we also have the word specifically. That's at the end of the middle of the first paragraph. We're told that the legislation will put beyond doubt that HMRC's use of large-scale automated processes to give certain statutory notices is always and has been fully authorised. So it's validating the process. And if we look in the middle of the next paragraph, it says it will protect very substantial sums of tax. It will preserve the status quo for taxpayers in HMRC, so nothing was going to change procedurally, and it merely confirms the validity of HMRC's long-standing and widely accepted operational practice. So if the court is able to take that, there is at least here an indication of what Section 103 was aiming to achieve. In short, and we'll see this consistently through the legislative material, the purpose of the legislation was not to dispense with the need for evidence of the officer involvement in the process. What it does is puts beyond doubt that the process may, in part, be automated. And if I can ask the court to turn to page 24, which is the next document, there is effectively a summary of a technical note. And again, it says pretty much the same as what the FST had said. Puts beyond doubt that HMRC's use of large-scale automated processes to give certain statutory notices is and always has been fully supported by the legislation. But we also have a fuller technical note starting on page 26. And if I could I'm going to rely upon paragraphs 1.3 and 2.1. I don't know whether the court would just rather read them to itself at this stage.
Sorry, which paragraph?
Page 1.3 on page 26 and paragraph 2.1, the next paragraph.
Thank you. Well, it just repeats the same.
It does. It emphasises it's a technical clarification at 1.3, and we have and we actually have a statement saying the policy intention. We actually have those words. They don't have to be inferred. They are quite clearly there. And similarly at paragraph 2.4, the government intends that the legislation will apply both retrospectively and prospectively in order to safeguard revenue challenges charged since automated processes were introduced. And at paragraph 2.5, just the opening lines, this is a new policy and nothing will change for taxpayers.
This is not a new policy.
This is not a new policy. So nothing will change for taxpayers. Existing practices were intended to continue, but now with the added comfort that they complied with the legislative scheme. I submit that it was long the practice, as confirmed in Rogers and Shaw, that an officer must be involved in the authorisation of the issuance of a Section 8 notice. Nothing in this proposal was going to change or remove the officer entitlement, remove the officer element from that process. Now, that was announced in October. The finance bill did not go through until the following year. My learned friend Skeleton makes reference to what was said in the finance bill process. No comments have been made about Pepper and Hart, and I'll leave it for my learned friend if she wishes to address that. But what I will say is, on the assumption that the material can be considered, it does not actually help my learned friend. The parliamentary extract starts on page 28, but that deals with the previous clause, and it's only clause 100 at the bottom of page 28, which then becomes section 103, which we need to look at. And then we can see the FST's name at the bottom of the page.
So page?
Bottom of page 28, we can see the heading section 100, sorry, clause 100.
Yes.
Which means section 103. And then we have the actual text over on the page 29. And it's from this passage that my learned friend cites in her skeleton argument, but she doesn't take the full passage. So I'd just like to highlight aspects that don't make their way into my learned friend's skeleton. The opening lines, clause 100 is a technical measure that makes changes to put it beyond doubt that tasks that are being done by an individual officer of Her Majesty's Revenue and Customs may be carried out by HMRC using a computer or other means. And the final bit is the last sentence of that passage. So just before we have Ms. Baldwin. Decisions made by HMRC officers are often given effect by computer-driven processes so that HMRC can assess and collect taxes in the most efficient and cost-effective way. So what I derive from that is that processes are still officer-commenced, but can involve the automation at a later stage in that process. The need for officer involvement becomes clear also in the Financial Secretary's response to various questions. So the officer is not being sidelined, it's just simply that the officer's tasks may be carried out using computer. If I could ask the court to turn at the bottom of page 29, just above Mr. Streeting's name, we have a paragraph, and the first sentence is, the changes made by the clause will clarify that tasks being done by an individual officer of HMRC may be carried out by HMRC using a computer or other means. It is a bit repetitive, I do hasten to add. But the point is, this is the point which is being made time and time again to Parliament and to the wider world. What is the purpose of this legislation? And then we also have a question from Mr. Streeting and Ms. Thewlis, both asking about, well, are we moving into the world of AI? And Mr. Norman then responds at the top of page 31. The Honourable Lady and the Honourable Member for Ilford North raised the question of decision-making more generally. I think I have in a way spoken to that, but I recognise there is a distinction between the automated exercise of a decision and the capacity to make a decision itself. In other words, what the Financial Secretary was doing was saying, we're not in the AI world. And remember, this was all done before ChatGPT came along. We're not in the AI world. It's just simply an officer makes a decision, but it can be given effect by a computer. Finally, although I don't believe it will actually add anything, I just want to highlight the explanatory note that accompanied the clause through Parliament. It's on page 33, but as I said, it doesn't really add anything. But I just want to make sure the court has got the full material. That, therefore, is the history. It is now probably time I take this court to section 103 itself. That's in the authorities bundle, page 57. And I'm going to work through the first 4 subsections. As I said, 5 and 6 deal with commencement and transitional matters that aren't of relevance today.
Sorry, just give me that page reference again.
Page 57, my lord.
There you are, Mark. Yeah. Thank you.
So the first part, the first subsection is key. It recognises that statute sometimes requires actions to be taken by an officer. And we've seen that with section 8. And anything capable of being done by an officer. And then the operative words are, may be done by HMRC, whether by means involving the use of a computer or otherwise. As to what that actually means, we'll have to look at in due course. Subsection 2 then gives 6 examples, and no one is suggesting that this is a comprehensive list, of functions that are required to be carried out by an officer. And section 8 is one of the requirements to return is within that first paragraph. And I accept that being issued with a section 8 notice is not necessarily the most dramatic event that a taxpayer might experience. But we can see more significant events taking place in B, C, D, and F. In B, an officer has a limited right to make a unilateral amendment to a tax return. So when you send it in, the officer can say, I'm changing it to this. The taxpayer can then respond by saying, actually, I don't want you to change it, and that is effective is cancelled. But effectively, the officer can start the process by amending a return under section 9ZB. C, D, and F deal with making assessments and including penalty determinations. So a number of processes that an officer is required to be involved with, and we now know that that can be done using a computer or otherwise. And the comforting words of the FST, the earlier pre-legislative material, and I would suggest common sense, that none of these tasks are being delegated to AI. There is nothing in section 103 that removes the need for officer input into the process. It merely can be executed by HMRC more widely, including the use of the computers. And what is particularly significant is it cannot remove the officer, because each of those 6 stages or 6 events, the taxpayer must either must or may respond to the officer who had started the process. So we've seen that in section 8, that the strict obligation is to file a return to the officer who issued the notice. Similarly, if you're challenging a 9ZB amendment, we don't have this, but I don't believe this to be in dispute, the notice challenging it or rejecting it is sent to the officer, and any appeals against assessments, etc., and determinations must be made to the officer. So in all those cases, the officer cannot be sidelined because the next stage would leave the taxpayer in a quandary. How do I respond if there's no officer? So it's quite clear that the officer involvement is paramount and remains paramount even after the enactment of section 103. Moving on to subsection 3, this follows on from subsection 1 and actually says what happens. Anything done in accordance with subsection 1 has the same effect if done by an officer of revenue and customs, brackets, or where the function is conferred on an officer of a particular kind, an officer of that kind. And that's because certain statutory functions can't just be carried out by any officer, but ones who are specifically authorised for that process. So subsection 3 ensures that the validity applies even if it's a function that must be carried out by a specific officer. Reading back to subsection 1, it can then, the follow-up processes can be done by HMRC more widely, which would be any other officer, or using a computer. And what the Upper Tribunal suggested, and I submit it was wrong, is it suggested that subsection 3 swept away the idea that certain functions had to be carried out by authorised officers. In other words, a parliamentary legislative safeguard was being swept away because anything can be done by any officer. I submit that is incorrect.
By a particular kind of officer.
It has to be done by the particular kind of officer, but the follow-up, the administrative tasks as a result of the decision being made can then be carried out by any officer.
Can you give us a specific example of something, a function, which is conferred on an officer of a particular kind?
Indeed. When HMRC seek information in the course of an inquiry or investigation, their principal provision for providing information is Schedule 36 to the Finance Act 2008. The basic requirement can be carried out by any officer. But if the information is, or if a document is more than 6 years old at the time the notice is given, then the notice must be authorised by an authorised officer.
And what does an authorised officer mean? There's a class of...
There is a class, I think it's either by grade or experience. There is somewhere, I'm not sure whether it's actually on a website somewhere, but there is definitely within Parliament Street a document saying who is authorised under certain purposes.
Right, and can you, I'm sorry, repeat what your submission is about the effect on that of subsection 3?
In that particular example, the authorised officer will say, I'm authorising the request for the provision of earlier, of old documents.
Yeah.
Now, that's probably not the best example for illustrating section 103, but effectively, if there is an administrative task that needs to be done to cement that authorisation process, that can be carried out by any officer and can be carried out by and conveyed to any other officer who then issues the notice. This is not, the example I gave you is not an example of a notice that has to be given by the authorised officer. It merely has to be with the consent of an authorised officer. So, Lord Justice Nugee, I hope I haven't sort of then confused you.
Well, I'm trying to understand how you say subsection 3 assists your argument, because I think you say that there is here a distinction between your case and the respondent's case
Yes.
as to what the effect of subsection 3 is, and I'm afraid it's my fault. I haven't quite got my head around what the practical difference is on the two cases.
I'm trying to come up with a better example.
Thank you.
Let's hope that this one comes up trumps. No, unfortunately, the example I was going to come up with does talk about an officer, and they're just their internal safeguards. So I gave an example of where it specifically says an authorised officer. Maybe over the adjournment, I will scan some other references to authorised officers.
But your submission is that subsection 3 does not remove the requirement for there to be a particular type of officer carrying out a particular function. Whereas I think Ms. Chowdhury's submission is going to be that it does remove that requirement. Is that right?
That's what the Upper Tribunal said. Yeah. The Upper Tribunal said Section 103 was sweeping away all these safeguards about authorised officers.
Suppose, I mean, I know we're going to come on to an argument as to what HMRC means, but just looking at the words of subsection 3, if HMRC do something in accordance with subsection 1, and subsection 1 says anything can be done by an officer, can be done by HMRC.
Yes.
And subsection 3 says if HMRC do that, it has the same effect as it would have where the function is conferred on an officer of a particular kind, an officer of that kind. So why does that not mean, suppose you have a statutory provision which says this notice can only be given by an officer of grade 3 or above.
Yes.
And actually, all that the tribunal has before it is a notice issued in the name of HMRC. Yes. Why is that not something done by HMRC within subsection 1, and therefore has the same effect as if it had been done by an officer of grade 3 or above? That, as I understand, is the argument you're facing.
Yes.
And I haven't quite understand why you say that's a misreading of the subsection.
There are 2 points to that. One is, if you look at subsection 1 on its own, there is an element of circularity, because HMRC, on my definition, means officers anyway. So I will explain why
we're going to come on to that
when we look at the history.
Yes.
What I'm saying is that word HMRC means nothing in the case of an ordinary officer issuing a Section 8 notice. The value of this provision of the parenthetical words, the use of the computer. So an officer can involve the use of a computer in the process.
Sorry, so you're saying subsection 1, we shouldn't get hung up at all on the officer bit. Yes. All it's doing is saying the officer can use a computer in the process. That's
Indeed.
it.
That's effectively the effect of subsection 1, properly construed.
So, just so that I work this through, what you say, subsection 1 says, is an officer needs to do what an officer always has done.
Yes.
Which is, in this case, presumably, decide to issue a notice in relation to the filing of a tax return. So you would say in each case of each person around the country, of which there are many, an officer has to decide to to send a notice requiring that person to file a tax return. I just want to be absolutely clear. So am I wrong already?
I'm not expecting, if let's say there are 10 million taxpayers out there, I'm not expecting 10 million individual decisions.
Right.
We have seen in Rogers and Shaw that it's sufficient for officers to determine the criteria, the parameters, and for the computer to do the work.
What does that mean? Sufficient for the officer to determine the parameters. That is, we've got a list of 10 million people, and notices need to be sent to them.
Yeah. And
so what does that in reality mean? It means an officer has to look on a screen and see the 10 million names and say, I want the computer to send notices to these people. In other words, is it all that you're saying is that there has to be an officer, query what that means, a member of staff, somebody who at some stage has said, I want myself, or more likely someone else who is capable of doing it, to program this computer in order to require these notices to be sent to the people who've also appear on a list which has been thrown up by the computer. Is that all you're saying?
Yes. Maybe it helps if I ask you to turn to
I'm sorry to be so slow,
No, it's
but
not
I
at
just
all.
need to see it in real terms.
No. When I started in tax, we had local districts, and tax returns were issued in the name of the district inspector, and the district inspector's name was on the front of the tax return. That's and even in the early days of self-assessment. But the late 1990s is a different world from where we are now. If I could ask you to turn to what was said in Rogers and Shaw, so we've actually got a summary of the evidence that satisfied the Upper Tribunal in Rogers and Shaw.
Just before we
yes, of course.
do that, let's start with some very basic propositions. Not everybody pays tax. Some people don't have a large enough income to pay an income tax at all. Quite a lot of people pay tax but don't file tax returns. If your only income is income from employment and it's paid through the PAYE system, you never have to complete a tax return.
Unless you're sent a notice.
Unless you're sent a notice.
Yes.
So somebody at some stage must decide which of the, I don't know how many millions of taxpayers there are, but let's say there are 30 million taxpayers, which of them are going to be sent a return?
Yes.
And what I think we're struggling with is, what is the process by which a decision is made that we lucky people get returns each year and other lucky people don't get returns each year? And you're about to show us the evidence. Is that
answering my Lordship's question, I'm not going to show you that because that is something which is done, I still say Somerset House, in Parliament Street. It's done, there are criteria that HMRC determine of a non-statutory basis, I hasten to add, but they have their own internal criteria as to who should be getting a tax return.
All the Parliament says it's up to HMRC to decide whether to ask people to file tax returns.
Yes.
And presumably the intention is that if there is material suggesting that somebody is liable to self-assess tax over and above PAYE, then that's a good reason for sending them a notice requiring filing of a return.
Extremely good reason. Yeah. A taxpayer who has an obligation to, or has a tax liability that's not covered by certain types of income and doesn't get a notice is actually under positive obligation to notify HMRC within 6 months of the end of the tax year, with the likely consequence that that taxpayer will then get a Section 8 notice to follow. That's Section 7 is the obligation. But there's a mismatch between HMRC's practice as to how the criteria they use to determine who is the lucky recipient and Section 7. But strictly speaking, if you haven't been given a notice and you're not under an obligation under Section 7, then you don't have to worry about a tax return for the year.
But let's go back to what was worrying us, I think, which is what is the process that takes place and that you say is not displaced by Section 103?
And maybe if it helps if I then look at paragraph 56 of Rogers and Shaw, page 176 of the authorities bundle.
Paragraph
56.
Yes.
So 4 witness statements were produced to the Upper Tribunal in that case. As I said, the case was not remitted back to the First Tier, but the Upper Tribunal then dealt with it. And the officer of Officer McClure talks about a team of HMRC officers known as the Operational Excellence Business Delivery SA team, formulates and keeps updated criteria for deciding which taxpayers are required to submit tax returns. Mm-hmm. Having formulated those criteria, HMRC's computers then perform an automated scan of their database to identify the taxpayers who meet the criteria. A small team of HMRC officers then manually checks a small sample of 200 cases, essentially checking the output matches the relevant input as a high-level check of the automated scan. And then the witness statements of Officer Simmons and Hodge explain that HMRC themselves send notices to file in digital form, and that HMRC have outsourced the function of sending out notices in hard copy form to a third party. Now, has that answered my lady's question?
That's very helpful, thank you. But I'm just concerned that we might be going down a slight blind alley, because I'm not sure that Ms. Chowdhury would say that the situation is any different. And she's not suggesting that, as I understand it, that somehow this is all to be done by AI and the computer has taken over.
Absolutely.
And so I'm just trying to see
why I'm talking about AI.
No, not why you're talking about AI, but where the real chink is, the gap between you two. Because I think that it may be less or non-existent, less than you're suggesting. That's why.
Indeed.
To get to the bottom of it.
I don't know whether the court has taken the trouble to look at my very, very lengthy skeleton argument for the Upper Tribunal. We were dealing with lots of issues, but when I saw HMRC's own skeleton, I was able to put in a very short reply saying, we've narrowed down the issues. Because the issue which I think divides us is whether Section 103 overturns the need to prove the involvement of an officer in the process.
So let's be clear between, and perhaps it is clear to everyone else except me, so please bear with me. Neither of you are suggesting that the process is any different, in essence, from what is set out at paragraph 56 of Rogers, which you've both, I think, are content with. Your concern is that that it's the issue of proof that, and let's call them members of staff, because I don't think there's really any distinction between an officer and a member of staff in this case. We're not saying there are officers on one pedestal and staff on another, that it's necessary to prove that a member of staff or members of staff at least did what is set up in paragraph 56. And it's just that issue of proof. And that is all that we're arguing about.
That is indeed all we're arguing. That if one remembers the chronology, Rogers and Shaw, the decision came out on the 30th of December 2019. So by the end of 2019, HMRC knew what evidence was adequate to answer the question we were putting to them. But when they put their evidence, they put in a supplementary witness statement in post Rogers and Shaw, and they still failed to evidence it. So it is down to, it's more than possible that the processes that were described in 2015, 16, 17 in paragraph 56 applied equally in respect of the earlier that we're looking at. But we don't know, we don't have evidence. So it is down to they haven't proven the process.
This is all very sad. Yes.
And as I said, the point was, it wasn't an ambush. They were given a year's notice. And actually, they were also told by the First Tier Tribunal, as a case management hearing, what they needed to put in that evidence, which they were given 60 days to provide, takes us to July 2019. They missed that. They asked a second time for a stay behind Rogers and Shaw. That was refused. They unilaterally put in evidence after Rogers and Shaw, and they still missed what could be described as an open goal.
Well, that wasn't the First Tier Tribunal's finding.
The first, no.
The First Tier Tribunal found that they did prove it.
They did, through inferences. And we say, as the Upper Tribunal did, that actually what they had produced was not enough to fill in the gaps.
So they scored, but then it was overruled by VAR.
Indeed. But yes, if it gives the court comfort, we are down to proof and evidence. I think I was still on section 103, and the only other point I just want to make is looking at actually, I'm not sure, did I fully address my lady's question on the authorised officer? Because I think we've still got that strand. What does 103.3 do so far as authorised officers?
Well, let's go back to 103 in the light of our little foray.
Yes.
So, anything capable of being done by an officer by virtue of function conferred on that officer, let's put it that way, may be done by HMRC, whether or not involving the use of a computer. And then subsection 3 takes you back into subsection 1. Anything that's within subsection 1 has the same effect as it would have if done by an officer, and an officer, if necessary, of a particular kind.
Indeed.
So please again explain to me your submission in relation to what we've just discussed about proof and how subsection 1 and 3 fit together. I'm sorry, I know you have done already, but I'll have to write it down.
The essence of my argument
Yep.
is section 103 is not displacing the need for an officer to start the process.
Okay.
And that's why I took you through the various examples in subsection 2, because the officer is still paramount. So an officer has to start the process.
But we have to remember that in this case, that isn't like an individual considering a file and thinking, I think we need to make an assessment here. This is something much more high level.
I'm prepared to accept that the process can be done at a high level, as we've seen, for example, in Rogers and Shaw in later years. Nevertheless, what Rogers and Shaw says is the process, nevertheless, the criteria, the instructions to the programmers, all done by officers. The checking of the output is done by officers. Therefore, when the notice lands on our doormat in May, whatever, of any particular year, we can have some comfort outside this court. It was done by an officer. But it could...
The checking by itself can't make a difference, because you only check a very small sample. And that it can't be a necessary part of the process, because everybody who's not within the sample of 200 is still going to get their tax return. The checking may well give HMRC comfort the computer's doing what it's been asked to do, and from that point of view may give the rest of us comfort that the computer's been doing what HMRC asked it to do. It can't be a necessary part of the process in an individual case, because the likelihood is that it hasn't been checked in an individual case.
I don't want to sort of put too much emphasis on this, because I don't think it's important, but I would actually suggest that actually the checking is relevant, because statistically it will probably show that the officer's instructions have been validly carried out.
I see, yes. And presumably in Rogers and Shaw, the evidence explained what the criteria were. We don't have the benefit of that, but one would assume that if someone had filed a tax return the year before, showing they had income from investments, then you'd be likely to send them a notice to file the next year.
I think HMRC work in slightly stranger ways.
Right.
I say that from anecdotal experience.
Yes.
People sometimes get taken out of the system because it might, either the legislation has changed and therefore someone with that profile might not need to do it. It might be just simply a case of we want to reduce the workload on members of staff because of reduced resources. The criteria are published, and I believe they were updated fairly recently.
Right.
But I do know that at least until recently, there was a general rule that anyone with an income over £100,000 was part of the criteria. But it's all non-statutory.
But as you say, it's published. So this is not some secret process, which is completely obscure. It's a transparent process.
There was one case in which there was a challenge to the notice. It was a case called Goldsmith, which was looked at by Mr. Justice Fancourt in the Upper Tribunal. And I remember having to refer to it in the before him in this case, because that was focusing on the words for the purpose of establishing a liability. We'll go back to the earlier words of Section 8. There was a dispute because HMRC knew how much tax was payable, and they were actually trying to crystallise a liability. The Upper Tribunal said, and there was a challenge in the form of a collateral challenge against the Section 8 notice through a penalty. And the Upper Tribunal said establishing a liability can also involve crystallising the enforceable debt. Don't know whether that helps, Your Lordship, but
It's all helpful. Thank you.
I was going to try to explain the relevance of the officer of a particular kind. So let's suppose, Lord Justice Nugee gave the example of suppose certain taxpayers are required to be given a notice by authorised officers to do a Section 8 return. It's hypothetical, it's a fictional example. But let's suppose the specific authorised Grade 3 officer has started the process. That officer, having made the decision that X must submit a tax return under my special regime, can then pass the instruction to a non-authorised officer to carry out the next stage of the process, i.e. putting it into the computer, and the computer can then eject it. So that's where I differ from the Upper Tribunal. I submit that what 1031, when read with 3, they're not dispensing with the special safeguards that authorised officers are there to protect. And remember, all the pre-legislative materials said nothing is changing in practice. It would be rather strange for all statutory safeguards to be swept aside. I submit they weren't being swept aside. They were just merely ensuring that the authorised officer doesn't have to be the one doing the mere administrative task further down the process.
But where, therefore, do you find in the words of subsection 3 combined with 1 that differential between the policy decision, if I can put it that way, and the administrative actual carrying out?
It may be done by HMRC, if you go back to subsection 1.
Yeah.
So the task, that's where the word HMRC then does have added meaning, because it then means it can be done, the rest of the task can be done by any other officer, whether by, effectively may be affected by HMRC, whether by means involving the use of a computer or otherwise. So the policy still requires the authorised officer to start the process, but the process is not invalidated for the simple reason that the authorised officer hasn't been involved at every stage. And we'll see the relevance of this when we look at the earlier, the 1970 legislation.
I'm sorry to have kept you enormously. I'm sure you need to get on.
I'm grateful. So the final point I want to make on section 103 is just subsection 4. It's actually just the first part, HMRC means what's then Her Majesty's Revenue and Customs. And the court might just want to look over the page just to see the definition of references to an Officer of Revenue and Customs. I'm not intending to take any time on that, but I just want for completeness. But we see, for the purposes of this section, the 4 letters HMRC are given a specific meaning. That is a term that is defined in the schedule to the Interpretation Act of 1978, which then refers one to the Commissioners for Revenue and Customs Act 2005, Section 4. So if I could just ask the court very briefly to turn to page 17 of the authorities bundle. I hope the court will trust me just to rely upon subsection 1 and not try to go into the Welsh equivalent, but the commissioners and the officers may together be referred to as Her Majesty Revenue and Customs. So we have a clear definition via the Interpretation Act of a term which was specifically defined for the purpose of section 103.
And this may be a question more for Ms. Chowdhury, but there's a suggestion in her skeleton that the HMRC is a legal entity, whatever that means. What do you say the status of HMRC is? Is it a body corporate? Is it a collection of unincorporated association? What is it? What is it?
If one looks at the earliest sections of the 2005 Act, we have commissioners who are appointed.
And there are 9 individual commissioners, or however many?
I'm not sure of the precise number, but there are certain, and I think they're appointed by letters patent.
And they are named individuals, and you can see who they are on the website.
Yes, certainly on the website, yes.
Yes.
And the commissioners may appoint officers for carrying out the tasks.
Yes.
And the union, I use the mathematical term, the union of the commissioners and officers under section 4.1 may together be referred to as Her Majesty's Revenue and Customs.
Well, I understand all that, but that doesn't make them a body corporate, does it?
No.
No. But it enables them to be sued in that name. I mean, we know that in cases like this, the respondent is always HMRC or the commissioner.
It's the commissioners.
It's technically the commissioners.
Whereas pre-2005, a lot of appeals were made in the name of the district officer, district inspector.
Individual named inspectors.
Yes. Although there were other decisions which were made at the board level.
Yes, I see.
Inheritance tax is one example, but also certain areas of anti-avoidance. So occasionally you get cases of and ILC.
Yes.
But now it's always the commissioners.
Yes, I see. And the commissioners they're not a body corporate, but it's just a way of referring to the individuals who are by statute responsible for all the decisions made by the staff and by the officers.
They are, I think it's section 1, maybe section 2, they're given statutory responsibility for, it's now referred to as the collection and management of taxes.
Yes.
But collection and management is defined as the same as care and management, which was found in the earlier legislation.
Yes. Thank you.
So that is section 103. But it's helpful to look at the source of the wording we found in section 103 and see where it first arose. And that phraseology was first used 50 years before 2020, in 1970. Now, my learned friend Skeleton suggests this is a new point. It was in my skeleton in the Upper Tribunal, so I suggest it wasn't, but I'll address that if necessary in due course. The Taxes Management Act of 1970 was enacted in March 1970. It was effectively a consolidating act to take effect from the 6th of April 1970. But at the end of May, the Finance Act 1970 was passed, and it made an amendment to section 113. So if I could ask the court to turn to page 8 of the authorities bundle. We can see the relevant version of section 113, including the inserts. Now, my learned friend, I think, has asked for subsection 1A to be sidelined. I'm not sure how it's relevant, so I won't address it at this stage. But what is particularly important is subsection 1b. So we're now in 1970. Computers were not necessarily as
omnipresent.
Omnipresent is the word. There was another word I was thinking of, but yes, omnipresent would certainly satisfy as they are now. But nevertheless, they were beginning to be used. And the revenue, inland revenue as it then was, clearly felt they needed cover for use of computers in the assessment process. If one looks at the older tax cases, one sees references to the assessment book, where assessments were written in the book. But where the board or an inspector or other officer, and I just pause there, you can see that we've got the board, equivalent to the commissioners, an inspector, using Lady Justice Asplin's idea of a slightly higher quality of officer. There were different grades and different qualifications with revenue historically, or an inspector or other officer of the board, have in accordance with section 29 of this act, so that's the assessing power, still is, or any other provision of the Taxes Act, decided to make an assessment to tax and have taken all other decisions needed for arriving at the amount of the assessment, and then the next words will look very familiar. They may entrust to some other officer of the board responsibility for completing the assessing procedure, whether by means involving the use of a computer or otherwise, including responsibility for serving notice of the assessment on the person or liable to tax. So what we have is a statutory cover for the use of computers as part of the process. After enactment of the Finance Act 1970...
As the second part of the process.
As a second part of the process.
You said the words would be familiar. I'm assuming you're referring to whether by means involving the use of a computer or otherwise.
Those are the most important part.
Yeah. But what is different here is for completing the assessing procedure.
Yes.
Those are not words we find in section 103.
Agree. Accept that. But what we have is the entrusting to some other officer of the board. So the mechanical work did not have to be done by the inspector or the board itself. It can be done by, if I may call him or her, a more junior officer, without there being any suggestion that the assessment was a nullity. And I would suggest that the words entrusting to some other officer of the board is the equivalent to what is now HMRC in the words which are slightly before the parenthesis in section 113.
And so you would have us read 103 to mean that decisions still have to be made by the officer and the officer of the requisite kind, but the completing the assessment can be done by others and by means of use of a computer.
Indeed.
And so 103 is just actually a replication, if that's the right word, of this provision.
Indeed.
So why did you need 103?
Well, I would personally have suggested, given technological advances, I would find it difficult to argue that 103 was actually needed. Because using the doctrine which my learned friend relies on later, statute always speaking, it surely must be obvious in the third decade of this century that one can use a computer as part of the process. However, it's probable, and I can only put it at that level, that someone within HMRC, the department, was concerned that if the statute spells out, in the case of assessments, that the computer may be used, there was a fear that someone could run the argument, well, if it's there in the sense of in section 1131B, but it's not there in section 8, well, maybe the section 8 process is invalid. I would say Section 103 was enacted as an abundance of caution. Now, I'm not going to suggest whether or not that caution was justified, well, whether a court would have upheld any challenge on that basis, but the caution, and one could see it from the pre-legislative materials, quite clearly says we're trying to avoid legal challenges to the process that's always been going on. We've had automation for many years. We don't want someone to upset this apple cart. So with retrospective effect, we are ensuring that the use of a computer has not invalidated the Section 8 process.
I may be wrong, but I think when you showed us the pre-legislative material, there was reference to there having been challenges.
Yes.
And I think specifically to Section 8. So ought we to look at what had been decided? There were a series of FTT decisions.
But not on this point. So there are two possibilities, my lord. One possibility is there was a challenge which never got to the light of day because perhaps the announcement or some other reason the taxpayer backed down. So maybe there was such an argument. We just don't know about it, but the revenue wanted to preempt it. Or it was actually this case that prompted it, but HMRC had misunderstood what our argument was.
Oh, I see.
But there isn't the case. It's not like Section 12D, where you can point to the preceding case law and realise why a particular provision was enacted.
I see. Okay.
But what I say is that it was done as abundance of caution, and all the pre-legislative material was confirming this. It was merely confirming the practice that has long been going on, and computers have been out there for many years. And reinforcing the justification for that concern, as I said, I'm not necessarily suggesting it was a right concern. If one looks at subsection 1D, this was inserted in 1989, by which time computers were far more commonly used. And we can see where an officer of the board has decided to impose a penalty, and in the old days, most penalties under the TMA, most tax penalties were issued under section 100 of the TMA, and has taken all other decisions, he may entrust to some other officer of the board responsibility for completing the determination process, whether by means of using a computer or otherwise, etc. So clearly, in the late 80s, someone either raised the challenge or preemptively prevented a challenge, saying, well, wait a moment, if subsection 1B says assessments can be used by a computer, well, we want to avoid a challenge in respect of section 100 penalties, and therefore they put that in, and therefore it's not an unreasonable conclusion that section 103 was filling in all the remaining gaps. Lady, are you? If, in short, what I say is section 103 put beyond doubt the use of computers as part of the section 8 process, and given the similarity of wording, it was doing no more than to do what subsections 1B and 1D did for assessments and penalties. And I say that's entirely consistent with all the pre-legislative material and the stated intentions of the provisions.
But some of those things which we've been looking at in 113 appear in the list at 103 too, don't they?
Indeed.
Make a determination under section 100 penalties, for example, and the assessment procedure.
There is definitely overlap. And I can't shy away from that. But the effective part of the provisions are identical. I would say section 103 was put there as an abundance of caution. And as far as overlap is concerned, it's not one of the authorities before this court, but Lord Hodge, in a case called Rangers, referred to tax legislation as not being a seamless quilt.
Not being?
A seamless quilt. It can be dangerous, in other words, to assume a narrow scope just because of the way the wording is. There will be occasional overlaps. And given the flavour of Section 103, I would say it was just done there as an abundance of caution. If I can move on to the 7th stage of my 9 stages, and this is the Upper Tribunal's decision. I've already taken you to the battleground on paragraph 32, page 77. I don't intend to repeat that. And then we see the historical background is set out in the subsequent paragraphs. I'd like to take the court straight to paragraph 38. Where the Upper Tribunal describes what it considers the mischief to be. And it talks about the doubt about the validity of fully automated functions. Now, I submit the use of fully automated does, the phrase, does somewhat cloud the issue, because I think it's now fairly clear that neither of us is suggesting there's anything about artificial intelligence. But if we move on to paragraph 39, the first half of paragraph 39 is explaining an argument about the effect of the definition of HMRC. That's not a point I'm positively advancing today, so you don't need to worry about the first part of paragraph 39, but I'm happy to expand upon it if the court wishes. But what I want to focus on is what I was reported to have said it was the important point. So it's halfway through the paragraph, about 8 lines from the bottom of the page. The important point is that by reason of the definitional provisions, there was nothing in 103 departing from the need for individuals employed by HMRC to perform or authorise functions. There was no longer doubt, as a result of Section 103, they could use computers or other automation to perform the function. But there still needed to be commissioner authorisation, as decided in Rogers and Shaw, under the old law. Therefore, my case was, and it remains, HMRC still had to adduce evidence to prove that the officers had decided the criteria to apply and authorise the system that would give effect to them.
That's an accurate summary of your position, both
Indeed.
before them and before us.
Yes.
Yes. Thank you.
Paragraph 40 then summarises my learned friend submission and what they call an overstatement of their concession. Now, I've looked at my notes of the hearing. I'm pretty sure that the Upper Tribunal has accurately and fairly reflected what was said at the hearing itself. And I would say that the concessions made are perfectly sensible. The idea that the human who starts the process has to be an HMRC officer, I say is not controversial. It cannot be done by an outsider without the authorization of an HMRC officer. And I would say it's uncontroversial that the need for the computer to be programmed to HMRC's instruction. So I suggest that the Upper Tribunal has correctly reflected what was said below. I'm not sure quite how far we will get by discussing what was and what wasn't said below, but I can either read out my notes, wait for my learned friend to respond, or we just simply focus on what does 103 actually do.
Let's go on.
Yes. So at paragraph 41, the Upper Tribunal makes various points about Section 103. Now, some of it does look, at first glance, pretty innocuous. But I suggest that paragraph 41 contains the seeds of the Upper Tribunal's error. So I'd suggest that paragraph 41 has to be taken with some care. If we look at sub 1, the intended effect of Section 103 is very broad. I'd say that that was not the intended effect of Section 103. Its scope is undoubtedly very broad and general, but it's not making any fundamental changes. I say that the intended effect was merely to validate the existing practices. If we go beyond the colon, the statement correctly notes that HMRC may do anything capable of being done by an officer, but one has to remember that HMRC is a defined term, and as we'll see shortly, the Upper Tribunal did not adopt the statutory definition within the same section.
So do you dispute that Section 103 is very broad and general?
It depends on what one means by broad and general.
Well,
it covers all officer functions.
The words look incredibly broad and general to me.
Yes.
Speaking for myself. That's why I'm slightly just trying to identify, do you dispute someone that it is very broad and general in its wording?
This is why I simply say, my lord, one has to be careful. Yes, it covers all officer functions, and therefore, in that sense, is very broad. But does it have a fundamental shift in the way things are done? No. And it was never intended to. So it just depends on which dimension one's looking at when one's looking at the terms broad and general. It was not sweeping away with all requirements for officers to be involved in the process. It was not sweeping away with any of the other statutory safeguards for authorised officers. It just merely said these functions, as broad as they may be, can be carried out through other processes after the initial decisions have been made. In the second subparagraph, over the page, again, one just simply has to remember that HMRC is a defined term. And then in subparagraph 3, the Upper Tribunal does refer to the wording of subsections 1 and 3, which seem to distinguish between officers generally and HMRC. But where I fundamentally disagree with that final paragraph is that final sentence. If HMRC means little more than the aggregate of the officers of HMRC, it would be virtually meaningless. HMRC is a defined term and can only mean what it is defined as being the aggregate of officers and commissioners. The important point about Section 103 is that it allows officers to delegate the mechanical tasks either to other officers or to computers to assist them with their functions. And that is made clear, the use of the computers in particular, is made clear by the parenthetical words in subsection 1, consistent with the history of the wording previously looked at in section 113. And indeed, if I just quickly flick down to the bottom of that page, the importance of those words are in fact what even the Upper Tribunal recognise to be the key part of the section. Moving on to 42, again, it starts by addressing the one argument which I'm not positively advancing. But again, I want to continue with halfway down the paragraph where it says, in our view. In our view, HMRC is being referred to here as the body or department itself, albeit a body comprised of the commissioners and officers of revenue and customs. I'll submit that that is wrong because Parliament actually defined HMRC to mean no more than the commissioners and the officers. Continuing, it is indeed correct that, this is the next sentence, that is that notices are sometimes sent out in the name of HMRC and not in the name of any officer. And that was validated by the Rogers and Shaw case. The validity was confirmed by the Rogers and Shaw case. But it is incorrect to say that they are not issued with a specific authority of an officer. As is common ground, there is not yet full automation of the tax administration in this country. Many functions require the specific authority of an officer, even if unnamed, and Section 8 is one of them. The Upper Tribunal confirmed that Section 8 does need to be started by an officer. And then the last two lines of page 82, we come to the words in parenthesis. which the Upper Tribunal says indicate the intended effect of the legislative change. And I agree with that entirely. That was the main aspect of Section 103. But where we fundamentally disagree is the next sentence, the final sentence of the paragraph, where the Upper Tribunal says they are obviously not there merely to permit an officer of HMRC to use a computer to assist them with their work. Given the history, I say that that is a wholly unsustainable proposition.
So you would have us delete the word "not" from the last sentence.
Absolutely.
That would be your submission.
Indeed.
Which is slightly bold, isn't it? That in 2020 the government are legislating to say people can use computers.
As I said, I would not have run the argument, I would be very uncomfortable running the argument saying it's an invalid process. But it was what we've seen from the pre-legislative material is there was concern about invalidity. So what's the easiest way of resolving that? The surest way is by legislating for it, because that's, I don't know what the cost is of a section in the Finance Act, but it's possibly cheaper than taking a case to the First Tier Tribunal, the Upper Tribunal, the Court of Appeal. It effectively resolves the matter once and for all. So I'm not going to suggest it's anything other than a bold submission that it was necessary. But given what Section 113 says, 1B and 1D, one can at least say it's an arguable proposition that where Parliament has gone out to say computers may be used here and here, Parliament should have said it elsewhere. It was there for the avoidance of doubt. And most importantly, as I'll be emphasising, it was not there to overcome the need to provide evidence of officer involvement in a particular process. So if I move on to paragraphs 43 and 46, this is where the Upper Tribunal actually decides that the purpose of Section 103 was to resolve questions of evidence. We can see that in part in, with a suggested intention at the end of paragraph 43, and we can see it even more clearly in the middle of paragraph 46. It is therefore no longer necessary, it says on page 85, as it was in Rogers and Shaw, to adduce evidence. That's the Upper Tribunal's decision. I submit that is wrong. I want to
Let me just catch up.
Of course.
46. So I've got the bit in 43.
Yes.
Towards the end of that paragraph, and then that's reflected in 46.
In the middle of the paragraph.
It is therefore no longer necessary.
Indeed.
Yeah.
And that's what we take issue with.
Yeah.
And what I'll be doing is going back to paragraph 43 and showing why the logic followed by the Upper Tribunal was wrong, which then led it to give the wrong conclusion. If I can pick this up just again in the middle of the paragraph, this section on any view.
Sorry, the middle of...
Paragraph 43, my lady.
Yep.
What the Upper Tribunal said was there are clearly some changes being made by Section 103. It was more than merely covering previous practice. And what the Upper Tribunals said is that the statutory safeguard for authorised officers to do certain functions is being swept aside. And I submit that that is wrong because I've already explained how 103.1 and 103.3 work together. And I've promised to give an example, try to find an example in due course. So because the Upper Tribunal thought that 103 was going further, it could then go even further. And I submit that that is wrong because it started from the wrong premise. But even if the Upper Tribunal was right about authorised officers' safeguards being swept aside, I still say that that does not justify deciding that the need of evidence of officer involvement in an automated process was also being swept aside. Then, with your permission, move on to the 8th and penultimate stage of my submissions, which should be fairly concise. Why the Upper Tribunal was wrong, over and above the reasons I've already explained.
I was going to say, I think we've had at least some of that.
Indeed. But I would say there are two further and even more fundamental clues that the Upper Tribunal reached the wrong decision about the purpose of the legislation. There is nothing in Section 103 that says anything about proof or evidence. Putting that another way, there is nothing in Section 103 that sets up a statutory presumption. Those are both matters that, if intended by Parliament, could easily have been done by Parliament. There are plenty of examples where burden of proof is dealt with in statute or statutory presumptions are set up. Indeed, if we focus on the intended effect of the legislative change, to use the Upper Tribunal's words, i.e. the words in parentheses, we see that actually all the intended effect of the legislative change is to permit and confirm the use of computers as part of the officer's functions. The second reason why, further reason why the Upper Tribunal was wrong, is if we look at the pre-legislative material. There is nothing there that says anything about proof or evidence. The word that keeps appearing in that pre-legislative material is to ensure the validity of the processes. So I submit that for those reasons, the Upper Tribunal's decision on Section 103 cannot be sustained. Now, the 9th stage of my submissions, which I'm confident I will be able to finish within 5 minutes, is just wrapping this up with Finance Act 2009. But is there anything that the court needs from me at this stage in relation to 103 itself?
No, I don't think so, thank you.
So we've looked at, and your leadership actually mentioned this right at the beginning, there are two issues. There's the validity of the Section 8 process, there's the validity of the penalty assessments. It's possible that the court will decide that actually it can all be answered by Section 103, but I wanted to, as an alternative, consider Finance Act 2009 and see how the provisions are dealt with there. So it's in the penalty provisions of Schedule 55. I'm focusing on paragraph 18, which is page 49 of the authoritative document. And it is only subparagraph 1 that we need to look at, where P is liable for a penalty. The statute then sets out 3 things that must be done by HMRC. Assess, notify, and then state in the notice the period in which the penalty is assessed. So that must be done by HMRC. What does HMRC mean in this particular paragraph? There is a definition provision, paragraph 27, on page 56 of the bundle. Subparagraph 3, HMRC's means, and it was then Her Majesty's Revenue and Customs. And for the reasons I've already explained, that takes us into the Interpretation Act, which then bounces back into the 2005 Commissioners Act and means officers and commissioners. Now, there are 2 possibilities, and I'll address them both very briefly. Either paragraph 18 is a function covered by Section 103, because we know that Section 103 is not comprehensive. So it's a reflection of the, in which case, if that's the case, I just simply rely upon my arguments in relation to 103. But this court might conclude that contextually, paragraph 18 is not covered by 103. Therefore, the only it has to be carried out by HMRC as defined, but the definition is an officer or commissioner, and there was inadequate evidence of that before the First Tier Tribunal, as concluded by the Upper Tribunal. So whether or not one goes via 103 or not, the argument on on Finance Act 2009 ends up being the same. There was insufficient evidence, and the definition of HMRC requires there to be evidence of an officer or commissioner.
Requires evidence of?
An officer or commissioner. They were put to strict proof, again, to show that paragraph 18 has been complied with. And I say that has to be done by HMRC. HMRC means officer or commissioners. We need evidence of it. And there was just a complete lack of evidence. Once in my life, I actually finished ahead of my target.
Thank you very
I'm
much.
very grateful.
Gordon.
Anything else I can assist the court with at this stage?
No, thank you very much indeed. Ms. Chowdhury?
I don't promise to finish before lunchtime on the appeal, but I ought to come quite close.
Very impressive.
And that's partly because we've been through quite a lot of the material I intended to take you to through my submissions. And as you will have heard, I will deal with HMRC's response to the appeal, and also then go on to make my submissions on the respondent's notice points. And as you'll have seen from the Upper Tribunal decision, we are now left with a very narrow point here in this court, and it does come down to the question of whether or not Section 103, FA 2020, removed the need for HMRC to prove the involvement of an officer in the process which is at issue in any particular appeal. Here it is the giving of a Section 8 notice. And the reason you will have seen that we need to determine whether or not Section 8 notice was valid is because that then determines whether or not the taxpayer was liable to the late finding penalties. It's always been common ground. You cannot be liable for a late finding penalty if you are not under an obligation to file your tax return by a particular date, and that obligation only arises if you received a notice to file.
Or a valid notice to file.
Indeed.
Because it's accepted that they were received, but
yes,
were they valid?
Precisely. So there was a challenge, I think, before the FTT as to whether or not the notice was served, but that then fell away before the Upper Tribunal. Now, we've already looked at paragraph 32 of Rogers and Shaw, which explains what are the substantive requirements for Section 8 notice, and that it must be under the authority of an officer of HMRC, and you'll have seen what was said in Rogers and Shaw, that it isn't a case of someone going through the entire list of all the taxpayers in the country and then deciding individually in respect of each one. And you'll have also heard my learned friend explain that in Rogers and Shaw, the whole reason the issue arose there was that those appeals had been decided by the FTT without the benefit of any evidence. And so that's why the Upper Tribunal decided to hear evidence for itself, and moreover also set out the proper course which a tribunal ought to take when faced with a validity challenge. And what HMRC's position is in this appeal, and indeed in Alum itself, is that following Section 103, the law has moved on from where it was when Rogers and Shaw was decided, and indeed when the FTT issued its decision in the present appeal as to whether or not you need to provide proof, because Section 103 does away with that requirement. And I'm going to take a slightly different approach from my learned friend who took you to various other points before taking you to Section 103. I would like to start with Section 103 itself first, by looking at the words, then maybe looking at some of the background material, because there are certain points in there we haven't seen yet, to reflect on its purpose. And broadly, my submission is that the words of Section 103 are clear as to what it's intended to do, and when we look at the background material, they support what I say is the purpose and why it was enacted. And just to signpost where I am going, I can make it quite clear. I disagree with my learned friend that Section 103 has the extremely limited effect he is arguing for, that all it does is allow HMRC to now use computers where they couldn't before. And so section 103, just to remind ourselves, is on page 57 of the authorities bundle. And I think we've got, as my friend pointed out, subsection 5 makes the section fully retroactive, and the carve out in subsection 6 does not apply. It had a cut-off date of 11th March 2020. And I will come on to this in a bit more detail. But broadly, what we say is that this does away with the requirement for having to prove officer involvement. And just to be clear, and I think we have touched on this already this morning, HMRC do not have sentient computers which can make decisions for themselves. There is an officer involved. That is the world we live in. And in that context, this sanction is introduced with a particular purpose, which is to do away with the requirement of HMRC having to prove each time the validity of notice is issued that an officer was involved by filing evidence each time before the tribunal. And one of the cases which was referred to in passing but we haven't seen is the Upper Tribunal's previous decision in Alum, which had also considered the effect of Section 103. And as in this appeal, Section 103 had come in between the FTT's decision and the Upper Tribunal's decision. And this is in the authorities bundle at tab 15, and if we could turn to page 275.
Gordon might have suggested, or I might have understood him to suggest, that the Section 103 point was overturned Alum. I'm not sure.
It was actually the first reason given by the Upper Tribunal, but there was a subsequent reason as an alternative. All I said was, this court doesn't need to worry about overturning Alum because there's still the other reason given.
Thank you. Thank you.
Yes, I hadn't understood it to be obiter.
No, I was just concerned to get to the bottom of that. Yes. Thank you.
So the slightly different issue in Alum, as you'll have heard, which was whether or not the notice to file was, Dr. Alum's return was a voluntary return on the basis that it had been sent in, or whether he'd received a valid notice to file. It's a slightly different case, and you'll have seen reference to Section 12D. And again, if we could turn, I've asked you to turn to page 275. And in paragraph 20, we had again this issue about, well, was there evidence before the FTT on the basis of which it could have determined the validity of the notice question. And without going too much into the history of the Alum appeal, broadly the FTT decided didn't really have evidence of its own as to the process followed in that case, and decided on the basis of the evidence in Rogers and Shaw. And the Upper Tribunal said, well, it shouldn't have done that. And in paragraph 21, however, it does say that the law has moved on, and then refers to Section 103. And if we then turn to page 278, and this is where the tribunal's paragraph 31 starts to consider the effect of Section 103. And what we and the arguments being relied on by Dr. Allen were quite similar to the ones being relied on by Mr. Marano, at least before the Upper Tribunal. And in paragraph 36, at the top of page 279, the tribunal rejects the narrow construction being relied on by the taxpayer in that case, which is broadly, well, HMRC means the commissioners and officers of revenue and customs, and all it does is allow commissioners to, say, exercise functions which previously officers could exercise, and vice versa. And at paragraph 36, the Upper Tribunal rejects this construction and says the ordinary and natural meaning of the words used in section 1033, we are satisfied that Parliament intended to validate all the notices referred to in section 1032, where they are issued by HMRC as a department, including such notices issued using a computer. That is the ordinary and natural meaning of the words used in section 1033. The reference to HMRC in this context is plainly to HMRC as a department. It is difficult to see what useful purpose Mr. Ridgway's narrow construction would serve. And as you'll have seen, the Upper Tribunal in this case considered that the Upper Tribunal in Alum had come to the correct decision and agreed with its reasoning. And indeed made further points. And my submission on the appeal is that none of the appellant's arguments come anywhere close to showing that their tribunal made an error of law in its conclusion that section 103 made it unnecessary for HMRC to now have to adduce evidence of officer involvement in the sending of notices to file, or indeed penalty assessments, and has instead some much other narrower purpose or effect. And before I do that, I should clarify this point where I say that the Upper Tribunal overstated HMRC's position regarding the as to whether or not evidence was required, and that it was necessary to have evidence that the notice, the computer was programmed to HMRC's instruction, which you've heard referred to in submissions and is indeed picked up in the skeleton. Now, the way the submission was actually put can be seen in my Upper Tribunal skeleton argument. It's at paragraph 28 on page 164 of the supplementary bundle. Yeah, yes, my lady. So it's just paragraph 28, and it was the point, which again we've been circling around this morning, that it's not HMRC are not I think the confusion stems from the use of the words fully automatically. It's never been part of HMRC's case that its computers can make decisions by themselves, or indeed can be programmed by themselves to issue notices. And I don't think I needed authority for the proposition, but I did provide one in the form of Ferguson and British Gas Trading, which was a very different case. It is in the bundle, but just to summarise what it was about, it was an individual who'd been sent a letter, a rather threatening letter by British Gas, and she brought a claim against them for unlawful harassment. And British Gas said that as the correspondence was computer generated, she should not have taken it as seriously as if it had come from an individual. To which the Court of Appeal quite rightly replied that real people are responsible for programming and entering material into a computer. And so, broadly, that is the submission which I was making, that computers are obviously programmed by somebody. But that doesn't really get to the question of, well, once Section 103 is in place, do HMRC nevertheless still have to provide evidence regarding the involvement of the person who, say, programmed or authorised the issue of the notice? And that is why And that basically brings me to what we say is the correct interpretation of Section 103, which is that if anything is capable of being done by an officer of revenue and customs as a result of legislation, or in relation to taxation or otherwise, that can be done by HMRC, inverted commas. Of course, that leaves a question of what is HMRC? One point, there is the reference which the appellant refers to, well, HMRC is a defined term. It means the Commissioners and Officers of Revenue and Customs. But that 2005 Act definition is not exhaustive. It just says, well, it includes the Commissioners and Officers of Revenue and Customs. And both the Upper Tribunal, Alum and Marano considered it meant, well, they refer to it as the legal entity. Perhaps the more precise definition would be the government department.
Well, is it a legal entity?
I don't think so. As in, it's emanation of the Crown. I say that I can.
It's a government department.
Yes, indeed.
Its employees are civil servants.
Correct. Yes, that's either section 1 or 2 of the 2005 Act. That officers are civil servants.
It's not headed by a minister, it's headed by commissioners, but it's answerable to the Treasury.
Yes.
In some respects.
It is.
But it's independent of the Treasury in the carrying out of its functions. It's the commissioners who
the commissioners, yes, the commissioners are entrusted with the collection and management of the tax.
Yes.
Of taxes. As you'll be aware, 2005, the 2005 Act is when the two separate departments, the Inland Revenue and Customs and Excise, were merged to form the Revenue and Customs.
And the revenue goes back to the 19th century and was entrusted with the care and collection of income tax in some predecessor statute.
Yes.
1890. I think 1890, I think. Yes.
Perhaps 1890. Oh, yes. It's the Inland Revenue Regulation Act, 1890. And Customs and Excise, again, have a very long and interesting history as a separate department.
Much older than Inland Revenue, I imagine.
I think that's correct. Yes. So all very interesting, but as to what is the position here in 2024, we would say it's part of a government department.
And as you say, it's an emanation of the Crown.
It is. I'm thinking of the fact that if, for instance, you want to bring an action against HMRC, you would, in relation to judicial review, that would be in the name of the King. It's a public body. Amenable to judicial review.
Yes. Okay.
So just so that I understand it, you're emphasising HMRC as in broad terms, a department, let's call it that.
Yes.
But you are accepting that the Section 4 of the 2005 Act refers to HMRC as commissioners and officers.
Well,
or are you?
I do, yes.
Yeah.
But I don't really see how that really gets the appellant any further, because it is it is always individuals in a department who take any action.
Mm-hmm.
As in, there isn't a non-human asset in the department which is doing anything. I think it's the Upper Tribunal who actually probably express it best. I don't have an issue with the way they express it in paragraph 42 of the decision. This is page 82. And so it's paragraph 42 where it starts off by saying it rejects the argument that the purpose of section 103 is to now allow commissioners to carry out functions previously which could be carried out by officers. And then it's the part which starts, in our view. And while the appellant takes issue with the last sentence, we would say, well, that's clearly correct. When we go on to look at the background material, if indeed we need to look at it, it's clear that the section was intended to be more wide-ranging than allowing HMRC in 2020 to finally be permitted to use computers.
Is the distinction, I mean, section 103.1 seems to draw a distinction between an officer and HMRC.
Yes.
And it says anything which can be done by an officer can be done by HMRC.
Yes.
HMRC, as we've discussed, is not a legal entity. It's a government department consisting of a certain number of individual commissioners and then a much larger number of officers appointed by the commissioners
Yes.
to the system. So it's a collection of people. And is your submission that what section 103.1 does is where a statute says an officer of the HMRC or an officer of the revenue may do X, now it's sufficient if it's done by somebody in the department. Is that
As long as it's done by HMRC, yes, it's done by somebody.
On behalf of HMRC, or in the name of HMRC?
Yes, yes. And we can see that from basically why we say, well, that's why we no longer need to prove that an officer was involved in the issue of the Section 8 notice. Now, Section 8 refers to how a notice has to be given by an officer of the board. We say if you've received a notice, it says it's from HMRC, it's issued by HMRC, it's sent to you by HMRC, it can be treated as having been given by an officer of the board. So it's almost a limited deeming, as it were. That's the whole point of it. And the reason why we needed it, which I will come on to, is because the validity of various types of notices were being challenged before the tribunal on quite a regular basis prior to its introduction.
Yes. Now, just to be sure I've understood, these days you can't be sure just because you receive something which says HMRC on it, but it does actually come from HMRC. There's an awful lot of bad actors out there.
Precisely. Yes.
Who send things in the names of other people.
Well, indeed, and that is a point that, well, if someone gets something which says this is from HMRC, but it's a bad actor, unlike, for instance, taking this case as an example, it's not going to be either preceded by or followed by correspondence from HMRC.
Nor will it be recorded on HMRC's microfilm.
Indeed. Indeed, it wouldn't be recorded in any of HMRC's systems. It is not going to be the subject of response by HMRC if it ever gets appealed.
Well, you're not going to be claiming penalties if you never wrote the letter in the first place.
Well, precisely, yes.
So, almost by definition, the fact that you're pursuing the case means that when it says HMRC on it, it is really you. Almost.
Almost, yeah. I wouldn't put it higher than almost. It's very difficult to see how, for instance, is someone, as you say, a bad actor, I would say fraudster, maybe a prankster, not very funny.
Usually fraudsters, I think.
Indeed, fraudster, were to produce such a notice, but then if you were to phone up, say, the correct number for HMRC...
They'd probably give you the wrong number as well. No, I mean, quite seriously,
yes,
people
yes.
do send fictitious
Absolutely.
demands
well,
and collect money.
Yes, but I think my point was if you were to actually go onto HMRC's website and find the correct number and then ring them up and say, I've got this notice, and you get, and well, someone...
You hope you get through.
I wasn't going to say that, representing HMRC, but the person on the other end would say, you can ignore it, or report it to the police or action fraud or whoever.
Sorry, this is a bit of a distraction. I'm trying to understand, because you say the section is designed to eliminate what you need to prove. But if you're pursuing a penalty, you do need to prove that you have sent the notice. But you say you do that simply by saying, well, look, here's the notice. It's got our name on it, and we're pursuing it.
Well, to some extent, yes, I would say that, which is why Section 103 was introduced. Because as you've seen from the background note, the point was coming up in almost every case. What is the process by which this notice was issued?
Yes.
And now, as you can guess, if it is being brought up in every case where there is, say, a notice to file or a penalty assessment or indeed any other type of decision, it is a resource issue. And that is precisely what the background material you've seen and some of the other material is getting to. That if you've got a large-scale automated process and you received a notice, you can treat it as a valid notice.
Thank you.
I'm sure you'll come to this, but whilst you're on this also, for Section 8, you have to respond to the officer. What happens to that? If you remember.
Yes.
It was pointed out by Mr. Gordon.
So that's Section
8. 1A.
Yes.
To make and deliver to the officer a return.
Yes. So I was going to go.
Please don't let me take you out of your course.
Right.
I'm sure you will just weave that in at some stage.
I think the short answer to that is that you will have, now most returns are returned electronically to a particular, and that would satisfy the requirement under Section 8, as opposed to having to send it to Mr. or Ms. X on the form, because we no longer have them issued in the name of the district inspector.
Mm-hmm.
And so I was then going to turn to the fact, the argument that, well, all that Section 103 is doing is expanding what Section 113 was. Section 113 was only dealing with assessment. Section 103 now allows it to be applied to other decisions. Now, Section 113 was introduced over 50 years ago. And as for a point about it being, I did say it was a new point, there is a limited reference to Section 13(1)(b) in the Upper Tribunal skeleton. I accept that, albeit it's not picked up by the Upper Tribunal in the decision. And what the appellant says, it was doing that Section 103 is doing no more than putting it beyond doubt that you can use a computer for carrying out various administrative tasks. I think I did. I should just point out in my skeleton, I think there's a missing negative somewhere in the last line. Hopefully you will figure it out when you read it. But when we look at Section 103, and this is why I sidelined 1A as well, you can see it is quite limited in scope. And it's introduced again back in 1970, the first two subsections at least. Sorry, the first, 1A and 1B, which we're looking at. 1A says, well, if one officer is carrying out a task, it can be completed by another. And 1B then follows on by that. So this is page 8 of the authorities bundle. And that, again, in relation to an assessment, allows one officer to take over the process of completing an assessment and enables them to use that either a computerized process in doing so. Now, I have 4 points in relation to this. The first is, as I say in my skeleton, these provisions have effectively been superseded by Section 103. It's far more wide-ranging in its scope. Secondly, if it really, when this section did not stop the various challenges which were being made to various types of HMRC notices being raised. Thirdly, if the change was as limited as is contended by the appellant, well, all HMRC needs to do, or the government indeed, would be to have just amended section 113. And fourthly, I've referred to 1970 a couple of times. I don't have authority on this, but I think we can take it as read that back in 1970, computers were much less used for carrying out admin tasks. It's more likely at that time that the whatever mechanical instrument was being used was either a typewriter or a calculator. And even I understand that video display units only really started taking off towards the end of the 70s and into the next decade. It isn't suggested.
We make no admissions as to whether we can recall those things.
And I'm going to leave that up there. And equally, section 113 is not referred to in any of the background material. That, well, we've got this section, but it only refers to assessments, and we need another section to allow HMRC to now be able to use computers in the same way they have been for the past couple of decades. Now, as for the various challenges which are being raised, you'll have seen we did produce a joint note for the Upper Tribunal, which refers to various cases. And the note itself, as you know, is at page 3 of the supplementary bundle. I'm not going to ask you to go through it in any detail at this stage. The key points from it are taken by the Upper Tribunal at paragraph 33 of its decision. Where it refers to how the cases in question included those where penalty assessments were being challenged, notices to file were being challenged, that's Rogers and Shaw. There were challenges to penalties under section 100 of the TMA. And some of those cases were all to do with the question about whether or not you needed a named or flesh and blood officer issuing the notice. And those challenges all rose in a relatively short period of time. I don't want to say something which I have contradicted in a note to which I have put my name, but between us, we identified that there were a couple of cases, I think Bosch has referred to in that 2013, but broadly, most of these cases started coming in post-2015. And what we say is that is precisely the purpose why Section 103 was introduced. And that is clear from the background material, which was before the Upper Tribunal and which we've included in the bundle. You've already seen the ministerial statement, which of October 2019, which said it's putting beyond doubt that HMRC can use large-scale automated processes. You were taken to the technical note, which was issued by HMRC on the same day, and to paragraphs 1.3 and 2.1. But could I ask you to turn to page 26 of the supplementary bundle? And it's paragraphs 1.1 and 1.2. And you'll see in particular in paragraph 1.2 makes it clear that the long established use of automation has been challenged in the courts. Whereas HMRC believed that current practices were supported by the legislation, but to provide certainty, legislation would be introduced in the next finance bill. I'm not going to place a huge amount of emphasis on Hansard. There is plenty of other material we can look at without needing to look at Hansard, but nevertheless it was referred to before the Upper Tribunal. And I would only refer to the top of page 29, behind tab 7. And in particular the second paragraph again. It referred to how HMRC's long-standing practice was being challenged in the courts. So the first paragraph we can see at the top of page 29 is the one we see in the statement itself, and then there's a bit more explanation from "if I may explain." Refers to the TMA being over 50 years old, and how HMRC's practices have, how HMRC administers tax system has evolved over time. And while my learned friend says he doesn't consider the explanatory notes to be particularly helpful, both the Upper Tribunal and both Allen and Marano do refer to them, and they're at page 33 of the supplementary bundle. And I would refer you to paragraphs 8 to 12 in particular. And the Upper Tribunal, having referred to all this material, then in HMRC submission correctly identified the mischief at which section 103 was targeted in paragraph 38 of its decision, page 80 of the core bundle.
There's a query of the word fully, because you...
Yes. Well, I think, again, we're going to end up in that strange place where we talk about computers making decisions by themselves. But the fact is, it is understood by everyone, indeed by Parliament when passing this legislation, that there is no such thing as a computer which makes decisions by itself at present, except in the realms of science fiction. Even a function which is described as fully automated nevertheless still has some human involvement. That is just the world we live in. And notwithstanding that context, Section 103 is nevertheless enacted to enable HMRC to carry out functions without having to prove the human involvement in each case. Because one of the points which was made by my learned friend is, well, maybe this section was being introduced in relation to, say, a particular case, maybe even this case. Well, perhaps we could also consider, well, Rogers and Shaw, which was handed down in December 2019. So that is after the announcement of the legislation, but before the section's enacted. So even though Rogers and Shaw is determined in favour of HMRC, it still leaves them with the problem of having to adduce evidence in each case where the question comes up. So just on that point about whether or not a process can be fully automated, well, bearing in mind that everyone is agreed that there is no such thing as present as a fully automated process, the section can only be providing that a notice is valid if it's issued by HMRC, without, whether by using a computer or otherwise, but it does not have to identify if the action was done by an HMRC officer or which kind of officer. And so HMRC submit that the tribunal correctly identified the mischief at which the legislation was aimed at. And in fact, what we would say is that the appellant's alternative interpretation of Section 103 renders it almost meaningless. Because it means that, well, there's no change in the requirement for HMRC to have to provide evidence in each and every case where there is a challenge to the validity. Especially where in the vast majority of cases where you have a routine notice, such as a notice to file, for instance, that notice would be issued using a computer. I'm just looking at the clock. I'm going to see if I can make one. I'm going to squeeze one more point in, and then I may want to come back. But I expect I'll finish within half an hour after lunch, the event, on this, and then move on to the respondent's notice.
I'm just worried about time altogether. I think that this isn't the moment, but during the short adjournment, please would you agree between you how you're going to divide up the afternoon?
I would imagine the respondent's notice point isn't going to take very long.
Okay.
So I think we'll be comfortable. So the one point I was going to make is, well, actually I have 3 points left and I can tell you what they are. The first is, we say that all of the appellant's complaints in the skeleton argument regarding the application of Section 103 are misplaced. In particular, there's a point made at paragraph 37 about how if treating notices issued by HMRC using an automated process as valid under Section 103 is going to somehow change the way HMRC will issue their assessments. The section has been in place for 4 years. It hasn't caused any change in assessment, and indeed that's not the purpose why the section was introduced. The other 2 points, I can actually deal with one of them. I will be able to finish that in the next 4 minutes. This question about the authorised officer. Now, if we look through the Upper Tribunal's decision, it doesn't refer... an authorised officer, I should explain, is a defined term in certain parts of the tax legislation. My learned friend referred to her Schedule 36 and the requirement to produce information to HMRC sometimes needs to be done by reference to an authorised officer. It has to be signed off. And there may well be completely different points here. HMRC do not suggest that Section 103 does away with the requirement for authorisation where the legislation specifically asks for it. So whereas in Schedule 36 there is a requirement for a information notice to be authorised by a particular officer, that still remains. I have another example, which is Section 20BA of the TMA, which requires an officer to give evidence on oath. Section 103 has no application and has no intention of doing away with the requirement for an actual officer to give evidence on oath. And so I say this reference to the authorised officer, for instance, actually is doing nothing but just confusing matters. There are certain specific acts within the tax legislation which can only be carried out by an authorised officer, such as an information notice, giving evidence on oath, and so on. And they are not affected by Section 103, which, as you've seen from the background material, is intended to apply to routine, large-scale processes which are mostly automated now. In the sense described in Rogers and Shaw, you have a small number of officers deciding the criteria. Computers are then programmed and the notices are issued in accordance with those criteria. I am going to be able to finish on the appeal, because the final point was in relation to the penalty notices and whether those are dealt with separately or not. It seems from the Upper Tribunal's decision at paragraphs 46 to 48, and this is page 85 of the core bundle, and you'll see in that discussion, and this is basically its conclusion on the Section 103 point, it does refer in paragraph 46 in the middle to both the notices to file and the penalty assessments. And it's even clearer in paragraph 48. So it would seem...
So the references to notices or the notices of penalty assessment.
Yes, it says to use evidence, authorise the criteria for an establishment and use of an automated computer to send notices to file or penalty assessments. So that's a more general reference. And then in paragraph 48, we see reference to the actual notices issued to Mr. Marano. The Section 8 notices, or the notices or penalty assessment, he had more than one.
Yeah.
So it would appear that the tribunal considered Section 103 applied equally to the Schedule 55 penalty notices. If, however, for any reason Section 103 did not apply, we would say precisely the same arguments apply in relation to the interpretation of paragraph 18, which again uses that definition of HMRC. It is 1 o'clock, and that, subject to any thoughts I have over lunch, those are my submissions in response to the appeal, and when we come back I will then address you on the respondent's notice.
Very grateful. Thank you very much. 2 o'clock.